May it pleases the Court, my name is Chan Shen Yao and I appear on behalf of the respondent Gordon Brown in the present case as the counsel with my learned counsel, Jackson Tan Jun Ye and Tan Jia Wen. We are here before your ladyships today to submit on two grounds. The first ground is that there is no proof of breakdown in the marriage, as the respondent did not behave in such a way that the petitioner cannot reasonably be expected to live with the respondent. Thus, Section 54 subsection 1b ceases to apply. And the second ground is that the division of property should be held in favor of the respondent, as he has been the sole provider for the household. Turning to the first ground, which was that there is no proof of breakdown in a marriage, as the respondent did not behave in such a way that the petitioner cannot reasonably be expected to live with the respondent. Thus, Section 54 subsection 1b of the Law Reform Marriage and Divorce Act 1976 ceased to apply. In support of this, the recent Supreme Court case of Owens and Owens, where the facts are similar to the current case, when Mrs. Owens filed her divorce petition, she included relatively mild details about why she wanted the divorce. Here is what she said about her husband's behavior. The respondent prioritized his work over home life and is often inflexible in making time available for the family, often missing family holidays and family events. This has caused the petitioner much unhappiness and made her feel unloved. During the later years of the marriage, the respondent has not provided the petitioner with love, attention, or affection, and was not supporting of her role as a homemaker and a mother, which has made the petitioner feel unappreciated. Moreover, the respondent suffers from mood swings, which causes frequent arguments between the parties, which were very distressing and hurtful for the petitioner, who has concluded that she can no longer continue to live with the respondent. The respondent has been unpleasant and disparaging about the petitioner, both to her and her family and friends. He speaks to her about her in an unfortunate and critical and undermining manner. The petitioner has felt upset and or embarrassed by the respondent's behavior towards her, as well as in front of the family and friends. In Owens and Owens, the legal test on unreasonable behavior was applied, and in that case, it was held that the respondent's behavior was not unreasonable to expect the petitioner to continue to live with the respondent. The test to ascertain whether the marriage has irretrievably broken down is set out in the case of Livingstone Starlet and Livingstone Starlet 1974, where it states that would any right-thinking person come to the conclusion that this husband has behaved in such a way that his wife cannot reasonably be expected to live with him, taking into account the whole of the circumstances and the characters and personalities of the party? There is an objective and subjective element in this test. The objective element is would any right-thinking person, and the subjective element is the effect on the petitioner. I submit that the marriage has not irretrievably broken down because, firstly, any right-thinking person would not come to the conclusion that the respondent's behavior is in such a way that the petitioner cannot reasonably be expected to live with him. In this particular case, the respondent is a sole provider for his family and covers all living expenses for the benefit of the family, as he wanted the petitioner to concentrate on raising the children. The respondent works from 7 a.m. in the morning to 10 p.m. at night every day, which is fairly reasonable as he is an engineer who is an expert for a development project, and he earns 10,000 ringgit a month. His work routine is not permanent, and he has requested for temporary patience from the petitioner because the project that he is dealing with is a mega development project that will bring in millions of ringgit to the country. This shows the high importance of the project that the respondent is working on. Moreover, he has promised the petitioner that after the project was completed, the respondent would take the petitioner and their children to England to meet his family and promise to take a long holiday after the completion of the project. Secondly, the effects of the respondent's behavior on the petitioner is not in such a way that the petitioner should not reasonably be expected to live with him. The petitioner was not affected in the beginning while she was fully occupied with her two children. However, she started feeling dissatisfied towards the end of 2013. However, it should be noted that the respondent is home at night and on weekends most of the time. On January 2015, the petitioner took two of her children back to Malacca because she could no longer stand the boring life in Perlis. While in Malacca, she spent her savings going to nightclubs at night and window shopping during the day. These activities could have been done in Perlis as well and not only in Malacca. In light of that, it would not be unreasonable to expect the petitioner to continue to live with the respondent. In Buchler and Buchler 1947, for example, the court said that the behavior must exceed in gravity such behavior, vexatious and trying though it may be, as every spouse bargains to endure when accepting the other for better or for worse. The ordinary wear and tear of conjugal life does not in itself suffice. In the present case, the respondent's behavior of working from 7 a.m. to 10 p.m. every day and working on Sundays sometimes does not exceed in gravity, as he is fulfilling his duties as an engineer and a provider for the family. Looking at the case of Ash and Ash 1972, Justice Bagnall thought that a violent petitioner can reasonably be expected to live with a violent respondent. A petitioner who is addicted to drink can reasonably be expected to live with a respondent who is similarly addicted. If each is equally bad, at any rate in similar respects, each can reasonably be expected to live with the other. In the present case, while the respondent is busy at work trying to complete the project and take the petitioner to a long holiday, the petitioner took their children back to Malacca and went to nightclubs at night and went window shopping during the day. On top of that, she was quite happy because she had a newfound love while she was in Malacca. This resulted in her not wanting to return back in Perlis and to the respondent. She only went back to Perlis after her children's persistent pleas to go home and to go back to Daddy because they felt insecure. This shows that the respondent had been a great dad and that the house in Kangar is their actual home. There should be no reason why the petitioner cannot reasonably be expected to live with the respondent. That, my lordships, concludes the arguments I wish to submit on behalf of the respondent.
May it pleases the court, my name is Jackson Tan Tzu Chiat, and I appeal on behalf of the respondent, Gordon Brown, in the present case. Continuing on the first ground, which was that there is no proof of breakdown in the marriage as the respondent did not behave in such a way that the petitioner cannot reasonably be expected to live with the respondent, I hereby submit that the petitioner couldn't prove that the respondent had behaved in such a way that she could not reasonably be expected to live with him. As my learned counsel has submitted, the marriage has not irretrievably broken down as a result of the working hours or patterns of the respondent. Firstly, any right-thinking person will not come to the conclusion that the respondent's behavior is in such a way that the petitioner cannot reasonably be expected to live with him. As the respondent is a responsible man who is working hard to provide for the household. Moreover, he has promised to the petitioner that after the project was completed, the respondent would take the petitioner and their children to England to meet his family and promise to take a long holiday after the completion of the project. Secondly, the effects of the respondent's behavior on the petitioner is not in such a way that the petitioner should not reasonably be expected to live with him. Whether the constantly happened arguments between the petitioner and the respondent prove that there is a breakdown of marriage under section 54 subsection 1b will be examined. On the facts, the petitioner is easily irritated from the respondent's working hours, so they tend to argue, and the respondent will come home all grumpy and easily irritated because he is so tired, so both of them will fight easily, plus the conversation about changing his work patterns sometimes ends up in heated arguments. It was submitted that the marriage has not irretrievably broken down because firstly, any right-thinking person would not come to the conclusion that the respondent's behavior is in such a way that the petitioner cannot reasonably be expected to live with him. The respondent has been working hard from 7 in the morning to 10 at night to provide for his family and thus is tired and would expect the petitioner to be thoughtful and grateful instead of complaining about his work time, which then lead to heated arguments. It is reasonable for the respondent to be grumpy and easily irritated as he is very tired from working all day. In the case of Ash and Ash, the court asked the question, can this petitioner with his or her character and personality, with his or her faults and other attributes, and having regard to his or her behavior during the marriage, be reasonably expected to live with this respondent? The answer in this case would be yes, as the respondent has already promised the petitioner that once the work project is done, the respondent will take the petitioner and their children to England to meet his family, and promise to take a long holiday and spend more time with the petitioner after the completion of the project. Those heated arguments would not have happened if not for the petitioner's continuous complaints of the respondent's work patterns. Both sides are at fault as it takes two to tango, and thus I submit that the respondent's behavior is in no such a way that the petitioner cannot reasonably be expected to live with him. This case will be yes, as the respondent has already promised the petitioner that once the work project is done, the respondent will take the petitioner and their children to England to meet his family, and promise to take a long holiday and spend more time with the petitioner after the completion of the project. Those heated arguments would not have happened if not for the petitioner's continuous complaints of the respondent's work patterns. Both sides are at fault as it takes two to tango, and thus I submit that the respondent's behavior is in no such a way that the petitioner cannot reasonably be expected to live with him. Furthermore, in the case of Joseph Jagannathan and Rosalind Joseph, in which the facts provide that the petitioner's husband filed for divorce on the grounds that the marriage has irretrievably broken down and that the respondent had behaved in such a way that he could not be reasonably expected to live with her. There was evidence that showed that marriage was not a happy marriage and that the home was filled with bitterness, strife, suspicion, and tension generated by frequent violent quarrels between the petitioner and the respondent. Long periods of silence between the respondent and the rest of the family, virtually daily absences of several hours of the respondent from the home where she resided at the matrimonial home, long periods of absence of the respondent from the home on other occasions, and by certain specific incidents involving the respondent. It was held in that case that the petition was granted and a decree nisi was ordered. This case proved that there must be to a certain extent that the respondent had behaved in such a way that he could not be reasonably expected to live with the petitioner. And in the present case, the respondent's behavior was not to the extent that he could not be reasonably expected to live with the petitioner. That, my ladyships, concludes the arguments I wish to submit on behalf of the respondent. I hereby beg that my ladyships would hold that the divorce is not granted following the decision of the Supreme Court in Owens and Owens. And if the divorce is granted, I beg that my ladyships will hold that the custody of the children to be granted to the respondent.
May it please the court, my name is Tan Jawan and I appeal on behalf of the respondent, Gordon Brown, in the present case. The respondent will respond to the division of property and beg that my lady will hold this case in favor of our client, Mr. Gordon Brown, and dismiss the claim brought by the petitioner. As removing to the petitioner's submission on division of property, I'll first look at the division of house property located at 1 Jalan Bayang, Taman Kebun Siam, 01530, Perlis, Malaysia, which is registered under the name of respondent, Mr. Gordon Brown. In order to determine the division of portion of the property, a review will be made to the Malaysian statutory provisions and also common law principles. Although Section 11 of Married Women Act 1957 enables parties, such as the petitioner to a marriage, to seek a declaration from the court pertaining to the title or possession of the property. By relying on Section 76 of Law Reform Act, Law Reform Marriage and Divorce Act 1976 LRA, which lays down the provision on division of property, the provision of division of matrimonial assets, the respondent will also seek a declaration from the court on the division of matrimonial asset. Although there is no clear definition what matrimonial assets are, with application of Section 3 of Civil Law Act 1965 that set the English common law as reference, gleaning from dictum of Lord Denning in the case of Washer and Washel, the term property from Married Women Act and the term matrimonial asset from LRA may be used interchangeably. As referring to the Section 76 subsection 1 to subsection 4 of LRA, either there is sole contribution or joint contribution of parties towards the matrimonial assets to uphold the equality of division between the parties of any assets during the marriage. the extent of contribution made by either party to the welfare of the family by looking after the home or caring for the family and the needs of minor children will be reviewed. As shown in the facts, the house property registered under the name of respondent Mr. Gordon Brown, which was bought by the respondent with petitioner's contribution on some furnishing together with some simple maintenance and repairs with petitioner's income of 900 ringgit through selling cupcakes. The respondent submits that the division of property should be held in favor of the respondent. With regards to the case of Chin Sat Lin and Lim Fa, where the wife provided 1,200 ringgit purchasing a piece of land with husband contribution of 400 ringgit, the court held in favor of wife by claiming that the wife was entitled to 3/4 of the land registered by way of a resulting trust created in her favor, and the remaining portion belongs to the husband, since the husband had only contributed 1/4 of the purchasing price of the land. By applying the same rationale to the current case, as the wife contributed only some furnishing together with simple maintenance which may not happen usually, the title or possession of the property should be laid in favor of the husband. There may be an argument raised by the learned friend on the application of the case of Nagapushani, which upheld the appointment of equal share to both parties, even the exact contribution towards the purchase of the house by both parties was not ascertained. There is a difference of facts as both parties in Nagapushani case have more equal contribution throughout the purchase of the property. Compare Nagapushani case to the current case, as the contribution of wife, which are some furnishing and some simple maintenance that will not happen often in people's daily household, the respondent submits that the principle and the rationale applied in the Nagapushani case should not be applied. Besides, the learned friend may also rely on the case of Li Yuyan and Lim Chanchi together with the case of Chin Shua and Lim Shutling, proposing that the wife had contributed to the matrimonial house by caring and rearing the children at home, fulfilling other general duties as a housewife together with contributing to furnishing the house and maintaining it. To counter-argue the argument, as stated in the facts, the respondent had been working hard and earning an income of 10,000 ringgit, which is so far greater than the income of the wife of 900 ringgit, and being the sole provider for the family, the division of property should be held in favor of the husband. In accordance to the division of the assets such as 2 cars, which are one registered under the respondent name and one registered under the petitioner name, we submit that the possession of both cars registered under the name of respondent or the petitioners should be remained. Referring to Section 76 of LRA, which provides a reference to the contribution made by either party to the welfare of the family by looking after the home or caring for the family and the needs of the minor children, we submit not to apply for the division of car bought by the respondent but registered under the name of petitioners with regards to her contribution by caring and rearing the children at home, fulfilling other general duties as a housewife together with her contribution on her car petrol. On the division of matrimonial assets of car, we submit to remain the possession of respondent's car as referring to the facts that both price and petrol expenses of respondent car are paid by the respondent with no contribution made by the petitioners. Thus, there is no application of the common law submitted on the division of the house property. May it please the court, this is all of the respondent response to the division of property submitted by the petitioners.